You've got mail.
Hi, my name's Mansell, and yes, we've made it to our second lecture.
Man's a ting. Nah, you ain't a ting, man.
Anyway, what is this video lecture about? This video lecture is about memes, appropriation of art, and copyright. How do memes, memes, whatever, relate to appropriation of art? Memes are a form of appropriation. Specifically, they take images from various TV shows or general pictures from events, and then you have a tagline underneath to describe some sort of thought or feeling behind it. But also there's a hint of parody and satire in some of these pictures. And this is my personal favourite. Art does the same thing, or has done the same thing as memes have done beforehand, and that is to appropriate material outside its genre or also within its genre. Before I forget, we will also talk about some American case law, and the American case law would be signified by this. America, fuck yeah! However, we won't be doing it for the English case law or for any case law in England because we're English, we don't do that.
The port is quite good.
Yes, quite good.
Indeed.
Most certainly.
What year is it?
51. Ah,
Delectable.
Indeed.
Yeah.
Some of you wondered why did I use the American cases along with English ones. The American cases offer us a persuasive precedent. They offer us a almost legal guesstimation of what the law could be and has been. We've segmented memes in 3 different categories. Yes, I've just made memes uncool. There are 3 types of memes I'd like to state, and this is within the whole idea of digital manipulation. There are ones where there's minimal digital manipulation or 0 Photoshop skills. There's also a midway between where there is some sort of digital manipulation, which is substantial, but not as substantial in terms of the legal term. Thirdly is when the photoshopping of a meme is completely different or has been changed so significantly that you can't recognize it. So what does that mean in terms of memes and appropriation? Well, before any copyright infringement must occur, there must be some sort of substantial borrowing of a previous image to the next image for there to be a form of infringement or copyright infringement. This is a very circumstantial test. The next point is that the courts will only look at the similarities between the works rather than the differences, so the onus completely changes. Therefore, it's not about what's the difference between painting A and painting B or photograph A and photograph B. It's the similarity. It puts the onus against the defendant to that matter. The infringement must also be of some sort of quality. So for example, we show this Pikachu, and then we show another Pikachu from Bad Gamer. For there to be a copyright infringement, the infringement must have some sort of quality, or it has to be good enough. So if you're fine. Copyright infringement for a painting is different from a copyright infringement from a photograph. With a painting, you will be infringing upon its copyright if you slavishly copy it. For a photograph, the infringement occurs when you have taken quite a lot or quite a substantial part of its compositional elements. And that has been discussed in Baurmann and Fussell. There's also a specific case called Rogers and Coons. Yeah! This will be discussed further on, but it touches upon this matter on what is compositional infringement and what is not. Digital manipulation. As we've stated, memes are a form of digital manipulation. Just resizing a picture does not constitute or does not give you a new form of copyright over their image. As noted before, memes they derive from either some photograph, a film still, or perhaps a mixture of both. There is a basic rule to digital manipulation and copyright, and this comes from the case of Mendler and Winterland Productions, America, fuck yeah! Where basically it states that digital manipulation of a picture to have its own copyright must destroy the original elements of the work. Again, this is a very circumstantial test. The English version of it, and it's again Antiques, Sportsfolio.com and Rodney, states it and touches upon this factor. There will be no infringement on an unoriginal photograph. So for example, we have a picture of Parliament and you go out there and you take a picture of Parliament. You won't have any copyright, and the person prior to you won't have any copyright either when taking that picture. However, if that picture's been taken with a group of gnomes or 4 puppies in front of it and there's a plane sweeping along and you've taken it at that moment in time, then you have your own copyright because it's something different and it's original and it's not generic. Defences. As stated earlier, we know that a meme starts off as a photograph or a film still, so there is some sort of infringement straight away. The basic way to defend any form of infringement is to talk about fair dealing, and the fair dealing in terms of memes would be the parody of defence, or the defence of parody rather. Fair dealing is a very difficult defence to describe, and it's described as by Justice Hart as an elusive concept. Fair dealing involves a question of degree and also a question of fact and impression. So basically it's circumstantial. Great for flexibility but really bad for certainty. Said there are factors that affect fair dealing. This was developed in Ashdown and Telegraph group, as well as IPC and News group. The basic factors are this: so whether the alleged fair dealing has commercially competed with the exploitation of the copyright work, which is by far the greatest sin. In addition, if that image or that part of information has been published already, if it hasn't, that's a breach of confidence. Also, there's a point by where how excessively you use that image or that copyright. So it's one thing, let's say, to use very small amount of clips from different places, but if you use a large amount in one place, you are taking the piss. And finally, there is a public policy in terms of if something's being produced that is in context of a public event or public current event, and everyone needs to know that. You also need to talk about sufficient acknowledgement or have significant acknowledgement of an item you have taken, but this does not affect parody. There's another most important point when involving fair dealing, and that is the use of non-commercial purposes, or not having a commercial purpose, and that's what would usually kill off any defense on fair dealing, and this is what happened in Coons and Rogers. But how does that involve memes? Well, memes don't have a commercial form of exploitation, they're more of a social form of exploitation. They're there to share jokes with individuals. However, if there is a very popular meme and someone gets the right lettering beneath it, so for example this, and puts on a t-shirt and then starts selling that t-shirt, whoever owns the image or whoever has created that image will chase after you in terms of recuperate some of the money or recuperate all the money that you have made by selling these t-shirts, because you have got a commercial purpose on it and you've used an image that does not belong to you. What is parody? So the highlighted definition is the one that I think parody is. So parody is a comic refunction of pre-existing material. This is hotly contested by 2 academics, Hutchion and Rose, and they've been battling over this definition for years, if not decades. As you just saw suddenly, the quotation parody regulation 2014 is the law trying to get round or trying to address the problem of parody by giving it a legal standing or a form of defence in fair dealing that has been incorporated in section 30 of the Copyright Design and Patents Act. This regulation was brought on by, thankfully, the EU, who have forced it upon us to get our together in terms of this one specific part of the law. And this was discussed in Deckmyn and Vandersteen. Let's just call it case C20113. They were talking about the specific meaning of Article 5 subsection 3k of the Copyright Directive. At the point of C201/13 confirmed the concept of parody under Article 5 subsection 3k. Namely, it was not subject to the condition that the parody should display an original character of its own, other than that of displaying noticeable differences with respect to the original parody work, that it could reasonably be attributed to a person other than the author of the original work itself, or that it should relate to the original work itself or mention the source of the parody work. The ECJ's requirements to see what parody is subjective to some extent, but also an idea of fair balance must apply, or the test of fair balance must apply, and that's balancing the original author's work but also the new author's or the parodying author's work as well. So again, it's a circumstantial test. Art history or art has for millennia borrowed or reacted to artworks prior to it. So there's this constant chain of causation in art. And appropriation is something very, very close to it, and it's almost contradictory to have copyright law by where it protects certain monopolies of ideas and creations, which goes against the grain of the whole nature of art by taking and sampling and moving on forwards. But let's look at it in general. Art traditionally used to take from mythology or biblical stories. Now in the 20th century, the whole idea of appropriation of art has gone away from these traditional aspects of biblical stories, ancient mythologies and history, and has moved on to something current. They've moved on to consumer goods, they moved on to stories that are within the century. But the drawback of that is the legalization or the legalifying, I don't know, but the fact that the law has spread into art, and also the development of commerce has made it more lucrative to have an idea and to reward people with those ideas. Therefore, any borrowing of such ideas, there is some sort of cost to pay. So if I quote Batman, everyone knows Batman as someone brooding and someone who had a difficult childhood but has no powers and fights supervillain. So when we talk about these things, there is a form of copyright behind it, because those that made it, so DC Comics owning the story of Batman and its rights and images, will be infringing upon that if we make any money from it. But this advent is recent. So if we look at the 1960s, 1950s with pop art, you have Andy Warhol taking from Coke, Campbell's soup cans, but also other images. He has taken from various newspaper clippings of various car crashes, and he doesn't own the copyright to that, but then he still uses that image. But that's still within the vein of art and art history. You also have the same thing with Roy Lichtenstein, by where he takes an image of one comic book and explodes it. And he tries to copy everything on purposely, slavishly, from that image from that one newspaper clipping of a comic book to a large canvas. But they get around the whole idea of copyright law. But if we keep on thinking about other examples, Yves Saint Laurent and the Mondrian paintings and his dresses, you can clearly see one is appropriating the images from the other, and one is doing it for a commercial purpose, and yet nothing has happened to them. And this is, again, and I forgot to mention it, that Andy Warhol and Roy Lichtenstein were commercial artists, and they sold the images of Campbell's soup cans, Coca-Cola bottles, in the droves, and yet did not get reprimanded for it. And this is where the Rogers and Koons case kicks in. This case is about Jeff Koons taking this image and him parodying it. The whole idea of parody and the double standards involved in art and law, as we saw from Warhol and Roy Lichtenstein, who aggressively sold their work and made it a commercial enterprise. Here we have someone who does the same thing but yet gets reprimanded for it. We have a photograph made by someone in California of these 8 puppies held by this couple. That was parodied by Jeff Koons. And there are various factors in this case, and again, I strongly advise you to read this case. One of that is the court said that it was not a parody, but if you look at the whole body of Jeff Koons' work, it suggests it. And for the court to say something is not a parody almost touches on the sin in previous cases where the court have stated explicitly they will not talk about what is and what is not art, but will talk about what is and what isn't parody. Especially when looking at Jeff Koons' body of work, it's all about parody. It's parodying not only art itself, but those who buy his art, but those who buy his artwork. However, when looking at the evidence, this is what saves it a bit, is that the correspondence between Jeff Koons and the person he's asked for to create the artwork stated explicitly a number of times, I would like this to be copied exactly, etc., etc., on a number of occasions. So the whole idea of a parody slightly goes by the wayside, and Jeff Koons wants to create something that's exactly the same as it is. So from photograph to actual sculpture. The whole idea of it, and this is what pissed off the judges, the work had a commercial aspect to it, which killed off any idea or point of fair dealing. But yet, again, if we look at Andy Warhol and Roy Lichtenstein, it's a bit of a double standard. It's a societal double standard rather than a judicial one, as those who have copyright would enforce it. Coca-Cola, Campbell Soup cans didn't need to, because it increased their social worth. It almost legitimized their brands as being not only low culture but a higher form of culture, something that permeates through society even deeper, or as deep as anything that is biblical or historical. Despite the Jeff Koons case, if we look at Shirley Lee Levine and her use of the fountain, or her copying of Walker Evans's works, and specifically doing so, you kind of see, again, there is no certainty, there's no logic to what artwork gets copyright or has copyright infringement and what doesn't and what doesn't. The whole point of this conclusion summary and this videocast is to stress that copyright does exist, but it doesn't exist at the same time. It's like artwork is affected by social conventions. Memes will not be reprimanded for their copyright because everyone is doing it. It'll be impossible to control it. It's as if, for example, we all bum rushed a club. It'll be impossible to stop the hordes of people getting in. You can stop one or two, but when everyone goes en masse, it's impossible. But there's also a key distinction in that, compared to piracy, in that memes are not there to commercially exploit themselves. They're there for social exploitation. There is an obvious loggerheads between the idea of copyright having a monopoly as compared to art, which doesn't quite believe in the monopoly but cares about authorship. And I think that's when the two kind of get it confused, and there's a frustration, or art historians and copyright lawyers get frustrated, and also artists get frustrated, and that causes an incredible amount of anomalies in art history and in judicial findings. But this is going to become more prevalent in the 20th century, and the 20th century more so than before, just because of how postmodernism relies on appropriating culture in this time period. Art is art when it meets a certain standard or is a form of talent that everyone accepts. Jeff Koons's puppies were not seen as a talent to be appreciated by the courts or by the person who saw the copyright being infringed upon. They didn't see that. But the Warhol or the Roy Lichtenstein, their works were seen as something fantastic, something brilliant, something that's out of the ordinary and marks them out as someone special. And if you don't believe the whole idea of society giving a double standard to those who are more gifted or brilliant, think about Jeremy Clarkson and him punching the poor producer. Jeremy Clarkson is an absolute idiot, or to say the least. But he knows how to produce a TV show, he's entertaining, that's his skill, and now he has another TV show, but hasn't been reprimanded for it. Or whatever reprimand he had was barely a slap on the wrist.
Don't move it.
Come and see me when you're a ting, yeah?
Shout outs. Usually I don't do these things because I generally don't have that many friends or enough of them, and I'm not that cool for it. But I'd like to say thank you to Mihai Broshin for passing on to me some of the law reports and legal articles I needed to do this videocast, and also for some future ones. So I would like to say well done to some of the members of the Brain Trust, Zoltan, Tuba Wakedi for getting called, but also for Kai Scarsbrook, Dan Crahan and Horatio Waller for getting pupillage. Good luck. And also for Gigi, you know who you are. Congratulations on your PhD. Elmaz, yeah, you're Elmaz. And also I'd like to congratulate Julia Queen and Colette Renton, who got called and are about to start their pupillage in the next few weeks or months' time.